everyone. My name is Omarai Guerrero. I'm the immigration manager here at WTLC, and I will be your presenter for today. Today we'll be talking about who is a victim when looking at U visa. This is part of our immigration relief series, and as always, we will start with the statute and regulations. So the definition can be found under INA 101A15. You can find non-immigrant visas specifically relating to you under INA 214P. And the regulations can be found in 8 CFR 214.14. So let's dive in. First one up would be direct victim. This is a person who has suffered direct and proximate harm as a result of the commission of a qualifying crime. So for all you that may not know, proximate harm is that the alleged harm must have been reasonably foreseeable as a result of the criminal contact. The closer the relationship between the action of the defendant and the harm suffered, the more likely the proximate harm is to exist. And then for direct is but for this action, this would not have happened. Lastly, please note that it doesn't matter if the person that ends up getting harmed is the intended victim or not. That's not the requirement. The link is always the harm suffered. So usually when I look at direct victims, the individuals that usually we use as examples are individuals that appear on TROs or ROs or were the ones that suffered the injury. There's also something called a bystander victim. USCIS will use its discretion on a case-by-case basis to treat bystanders as victims. It's usually an indirect injury as a result of a qualifying crime. When presenting arguments for bystander victims, it's good to use arguments that you would use for direct victims. And it's also good practice to just be able to use all arguments that you're able to make for your participant or client. There's also indirect victims. These are individuals that fall under the incompetent or incapacitated category. So the requirement is that the person must be incompetent or incapacitated and therefore unable to provide information concerning the criminal activity or be helpful in the investigation or prosecution of the criminal activity. Usually individuals that are under the age of 16 are considered incompetent, but it can apply as far as 21. But the best arguments that I've seen made are for those that are 16 and under. There's also the concept of the next friend. This area of immigration law has not been solidified or really explained. Most of this concept is based on civil concepts where a person appears on behalf of an incapacitated or incompetent person. So this is always an area that there's room for improvement. And then lastly but not least, who is not a victim? A person which is culpable, and then that means part of the qualifying criminal activity, being investigated or prosecuted is excluded from being recognized as a victim and therefore won't be able to apply under the U visa. If any of you have any questions or concerns, feel free to email me, call me at my mobile or my office. Thank you very much.